This is Quorum with Quorum's Quorum. My guest today is Samuel Levine, who is the director of the Bureau of Consumer Protection at the FTC. Sam is a true believer in consumer welfare and public advocacy. It would be a big mistake to look at his Harvard Law credentials and title and assume his career has been this strategic arc to power. If there's one lesson for lawyers in this episode, it's getting your hands dirty. Here's Sam. So Sam, thanks so much for taking the time to sit down with me today. I'm really looking forward to this conversation.
It's great to be here. Thanks for having me.
So I'm going to do something that I don't typically do and take a very chronological approach to your career because I think every step has some interesting premonitions for the coming parts of your career. And there's still really interesting jumping off points at each of those stages. So the first thing I want to start about talking about is your time in City Year. So I lived in Chicago at the time that you were in it, and I know the city promoted it a lot. So it was about a year that you spent in the program. Can you talk a little about the program and the impact it had on your trajectory to law school?
Yeah, City Year is an incredible program. Many people have heard of AmeriCorps. City Year was in some ways the precursor to AmeriCorps. It was a national service program founded in the late 80s. And AmeriCorps was in many ways modeled off the model of City Year. And that model was drawing people from a very diverse background, people who were dropped out of high school, people who were mid-college, people who had graduated college and were heading to grad school, which was my circumstance. Very diverse group of people recruited to serve their communities in different ways. I was working in City Year Chicago, where the primary mission was educational. We were not teaching in classrooms, which is sort of more akin to the Teach for America model. What we were doing is we were playing a support role. So I was doing a literacy tutoring throughout the day, generally one-on-one. I ran an after-school program after school, which was with I think dozens of kids, which was sometimes a lot of fun, sometimes incredibly stressful, and made me question whether I could ever be a teacher. And then when we weren't in the school, we were doing other service projects. City Year pioneered doing service on Martin Luther King Day. We would do random assignments like cleaning buses and doing customer service for the city. There was really a culture of service in City Year that inspired me and so many of my colleagues and just introduced me to people from walks of life I don't think I ever would have met any other way. So I could not recommend the City Year experience more highly for people who care about the world, care about public service, and just want to work with a great group of people.
Have you kept in touch with any of the people that were near here?
Oh, sure. I was just in touch over the weekend, actually, with someone who I had not spoken with since City Year. But other friends who I made there, I'm still in touch with all the time. You really, when you're in the trenches and you know, sometimes challenging situations, very low pay, you really become very close with people. And those are connections I expect will last the rest of my life.
Yeah, and I certainly had that when I worked on political campaign, which is very similar to that as a field organizer. And yeah, it's very low pay, very long hours, very
Yeah.
stressful. And yes, it's a bonding experience like no other for sure.
And it's not just that. We had to wear uniforms every day, which I don't know if maybe you had to wear a suit or something, but we had to wear uniforms every day to work. You've probably seen people in City Year uniforms on the train. And when we were on the train, we always had to stand up for people, which is the right thing to do. I learned a valuable lesson in etiquette in the city. Could not chew gum. It was very regimented how a City Year Corps member was to present themselves. So it was quite the experience.
How do you feel about that part?
You know, I think it made a lot of sense. What's so unique about City Year in contrast, and I don't want to say anything ill about other service programs, is it was not just drawing from sort of elite students from top universities. So the goal of City Year Chicago, for example, was that the demographics of the organization should reflect the demographics of the city. And that was true in City Year chapters all over the country. So I think part of the idea of having a uniform was an equalizer for people. We came from very different backgrounds. I mean, truly eye-opening in so many ways. But when we all put on that uniform, I mean, this is the same principle that the Army uses, that lots of, school uniforms. I mean, this basic principle that we're all wearing this uniform, we're all equal, and we're all reminded of when on that uniform representing city year and we have to behave in a certain way. So, I did not always love it. It was not fashionable. It did not fit well. It was not particularly comfortable. It was very hot in the summer. Um, but I think it really served the interests of the organization. I still keep my uniform probably in my closet.
And I wonder, have you ever thought about some application to the practice of the law? I mean, so much about law is there's bar associations and there's, your comics are like regulated, at the state level. And so there are standardized aspects of practice in that way. But have you ever thought about applying something like to the practice of law where there's some standard experience that no matter what your background or what your trajectory is, maybe you're heading big law, maybe you're heading to a small family law firm, that you have a standardized experience that you're all doing something that's public service minded. Of course, we got pro bono culture in the practice of law as well. Have you ever thought of any application like that?
In a way, far be it for me to impose, my view on law students, but I think if you're going into the law, you should know how the law operates for poor people. I really believe that very strongly. When you go through law school courses and you read cases, I mean, it depends on the course, but certainly in your 1L curriculum, you're not really always hearing about how the law actually operates on the ground for the people who have to deal with it, for the people who can't get fancy lawyers, for the people whose housing is on the line, whose government benefits are on the line. You learn all of these rules of evidence, but if you go into any, say, unemployment hearing in some local administrative forum in a city, it doesn't look like that. You learn about the rules of civil procedure and you look at what the eviction process looks like in a natural housing court. It doesn't look like how you learn it in school. So I do worry as people advance in their legal careers and gain power, if they don't actually have exposure to how the law feels, how it operates for the vast majority of Americans who can't afford real lawyers and for whom the stakes is not some victory on a resume, but is their home, is their government benefits, is their livelihood, is their family. When people don't have that, I worry that they don't understand the power of the law and how important it is that it operates with fairness.
And so I think that relates to a key experience that you had in law school at the Harvard Legal Aid Bureau. And so can you tell me how you chose there's lots of outlets for you in law school. How did you choose that clinic and how did it compare to other, say, clinics or other experiences you had in law school?
Yeah, certainly. So as I think this is true in most law schools, we couldn't do clinics as a 1L. But I did get involved in my first semester of my 1L year in a group called Project No One Leaves. It was founded about, I think, 2 years before I started school. People thought it was a project for the incarcerated population, which I don't know why you would join a group called No One Leaves, but to each their own. But of course, that's not what it was about. What it was about is this was 2009. There was a foreclosure, displacement, eviction crisis raging across the country and in Boston, where I was living. Massachusetts had a unique foreclosure. It's not that unique. It's true in about half the states in the country, but I think it surprises people. It has non-judicial foreclosure. So banks could foreclose on your home without ever taking you to court. And the idea of Project No One Leaves was for 1Ls to get in a car generally on a Saturday morning. And we would go through the newspaper and we would look for every house listed that for which there'd be a foreclosure auction. Again, no court process for a foreclosure. An auctioneer would show up in people's front yards and auction off people's homes. So we would scan the newspaper every week. And our goal, which we met most of the time, was to stop by every house in Boston facing foreclosure and encourage the folks living in that house to not leave and to instead go to an organizing meeting at a group called City Life Vita Urbana. And I started doing that every week. And maybe we can get into this later. It was, if you didn't live through that time or if you didn't see how, working class neighborhoods felt and looked during the time, it was hugely eye-opening for me. And I had just been working on the south side of Chicago in a city. It was still hugely eye-opening for me because by this time in 2009, and you had non-judicial foreclosure, so it was moving very quickly. You had whole blocks where property after property was facing foreclosure. You faced displacement of the entire neighborhood. So this immediately, I mean, piqued my interest is an understatement. I mean, I felt uh, deeply distressed about what I was seeing. And I was deeply curious about, well, I was sending all these people to these city life meetings, these organizing meetings. What are those actually like? So we can get into that later if you're interested. The long story short, I started going to the city life organizing meetings in addition to doing the canvassing door to door. And I realized that some of the leading folks providing legal services to people facing foreclosure were in the Harvard Legal Aid Bureau. So a word on that. Harvard Legal Aid Bureau is unique. Most clinics at HLS and generally are one semester. HLAB is a 2-year commitment. It's something you apply for at the end of your 1L year. You can apply for law review. You can apply for HLAB. You can't do them both. You have to choose one of them. Famously, Barack and Michelle Obama. Barack did Harvard Law Review. Michelle did the Legal Aid Bureau. Michelle made the right choice because the Legal Aid Bureau, what made it so unique is it was, in addition to the great foreclosure work it was doing, but it was a student-run legal clinic. There were clinical advisors who were faculty, but the organization was run by students. The cases we chose, the members we selected, the strategy in the cases, it was a student-run clinic. So that's sort of how I got involved in HLAB, and I immediately pivoted, unsurprisingly, to the work they do on housing.
Can you say some more about that population difference? Was it a timing issue for what had happened in the economy in the year that you transpired between when you were working in South Side of Chicago versus these neighborhoods in the Boston area? What neighbors in the Boston area?
What neighborhoods? Dorchester, Roxbury, to some extent Jamaica Plain, though by that time it was pretty gentrified, but we had our organizing meetings in JP. But we went to other, I mean, we went to towns outside of Boston too. We weren't able to reach every house, but I had clients. I remember I had a client in Somerville. I had a client I'm now forgetting the name of the town that was outside Boston, but it was not just in Boston. I think the big thing that changed from when I was so I was working in Chicago 0809. That's right. 0809. And then my first year of law school was 9 to 10. So I think two big differences. I was seeing the signs of financial distress in Chicago. Certainly people were leaving their homes, losing their homes, including people I was working with. But Illinois has judicial foreclosure. And pretty famously in my world, the foreclosure process in Illinois was pretty slow. Again, banks were bullying many people just to leave. But if you actually stayed in your home and fought back, you had to go to court. There was a long process. Massachusetts had non-judicial foreclosure. And by the time I was there, it was 2009, 2010. And even though the financial crisis kicked off in 08, I would say with the collapse of Lehman Brothers in September, the effects really started to cascade in 2009. So what I saw on the streets of Boston was actually far worse than what I was seeing in Chicago. And it was as I said earlier, deeply distressing.
And say some more about the organizer. You said, the organization that you encourage people to join and that you were learning from, and that was the precursor to HLAB. Say some more about that experience, because you were saying that there's more to that.
Well, so three different organizations. There's HLAB, there's Project No One Leaves, which is a group of students who go out, and I should say not just at Harvard, it was founded there, but Northeastern was very active. Suffolk Law participated, BU. It was a bunch of Boston law schools. So that's Project No One Leaves. And then there's a third organization, which is not student run. It's run by organizers to this day, City Life. And City Life was a really, this was around the same time in 2009 when people had been making fun of Barack Obama for being a former community organizer. But City Life was a group of community organizers. And that's not just a term I'm throwing around. These were professional, experienced, dedicated community organizers. And I will never forget my first meeting there, and just about every meeting subsequent. The way it works is you go into a room. It's in this former Sam Adams brewery in Jamaica Plain. And it's a big group of people. Most of them were people of color, but it was very diverse, both among the organizers and among the folks who were coming to the meetings. And the meeting would start by asking new members to stand up and say, my name is Sam Levine and I'm in foreclosure. And of course, or I'm facing foreclosure. And of course, what stood out to me at the time was how much this felt like an Alcoholics Anonymous meeting, right? I'm Sam Levine, I'm an alcoholic. And I thought at first, that's kind of odd. But when you think about it, it's actually, it's not odd at all. It makes a lot of sense. One of the things I saw when I was going door to door is I would tell people they were, your house is facing foreclosure. And they would say, no, nothing's, we're working it out. We're working it out. Sometimes that was true. Sometimes I would learn later. Sometimes they were maybe in denial about it, which is totally understandable. And a lot of the time they were just ashamed. And why would I even come to the door and suggest that they were behind on their mortgage and not realizing this is in the newspaper? So what you saw in city life was there was a lot of shame, that I think people felt about struggling with their mortgage. Some of these folks were working class, middle class. Some of them, by all appearances, more affluent people who had never experienced this kind of financial distress before. And it was, as with my uniform in City Year, I think it was a real way to unite people to stand up and say, well, I'm facing foreclosure. The bank's not returning my calls. They're not returning my faxes. Everyone stood up and said that, and it opened people up. One of the things that I remember, I don't think it was my first time going, but I remember one time going, two people who were neighbors, did not know they were facing foreclosure, realized they were dealing with the same thing. We even saw that we had relatives, both coming to the same meeting. And it was incredibly, again, at the time, people would be making fun of community organizing. Now I think it's more recognized that it's a powerful vehicle for social change. I don't think it was sufficiently appreciated then, but I really saw, because you had this big group of people and the idea was people power. Like, we are going to work as a collective to try to demand Massachusetts change its laws, to demand the Obama administration make it easier to modify mortgages and write down principal, to show up at eviction court, which we should talk about, but show up at eviction court. When people went to hearings who were part of City Year, they did not go alone. They were joined by legal advocates like me and others, and they had in the seats behind the court, behind the bar, they had their friends and neighbors from City Year there to support them. So this was really about providing support and a sense of community for people who were otherwise feeling very desperate and isolated. I know I'm going on and on, but books should be written about, in my opinion, about the on-the-ground movement to stop mass displacement in Boston during this period, because it was inspiring.
I think we'll want to pick up on this bottom-up approach to work, because I think that also affects legal practice, and I think it also influences the decisions that lawyers can make early or otherwise with how to make decisions about what to pursue in their career. I think it's I've been very strategic in my career in different stages and been very top-down at times, or often, I would say. And I think, I think it's also true that I've also used bottom-up techniques as well. And so I think that's going to be an interesting theme to explore, is the things that you learn from being boots on the ground about and how that's influenced the career decisions you made, and what anyone would see the objective success you've had in your career can be attributable to that technique and not some strategic gunning for the spot that you're in today, right?
Right.
So let's spend some more time on H-Lab then. So then, was it a no-brainer for you to choose H-Lab versus any other commitment you could choose to make?
Yes. It was a no-brainer. It wasn't a no-brainer I was going to get in. It was the, um, and, a lot of people applied, but I really wanted to do it. I'd be remiss to not mention that the clinical director of HSAP, again, student-run group, but there was a clinical director who was a professor, David Grossman. Um, he had been, we had as at 1Ls, we could request a faculty mentor, and he was the mentor that I requested. Um, Part of the reason going to HLab was a no-brainer is I got to know Dave, who was both I should say, the clinical director of HLab and sort of the advisor to Project No One Leaves. So I would frequently be in the car with him, around Boston, going around Boston neighborhoods. I hope we have an opportunity to talk about Dave. He was, I get emotional. He passed away in 2015, far, far too young. We started a fellowship in his name that goes on, but Dave was an truly inspiring, mentor to me and to so many other students who really, and he's the biggest reason I think I pursued HLab. He was a great lawyer, but he really saw the law as a vehicle for justice. But not the only vehicle for justice. He was a big believer in organizing. He was a big believer in people power. He was a big believer in a model we called the sword and the shield, where the lawyers would try to keep people in their homes and the organizers would help push the banks to do better, push the legislators to do better. So Dave really sort of inspired me about the kind of legal career that I could have, or that I wanted to have, where I could be, hopefully a force for social good. And, because he was director of HLab and he encouraged me to apply, and I very enthusiastically applied, and Dave became my mentor through the end of law school and beyond. I'll never forget him.
You mentioned being in the car with Dave, and that strikes me that, my understanding of other clinics and other kinds of ways to be involved in law school, you certainly have faculty contact and it's business hours kind of a thing in an office situation. But it sounds very informal and potentially long hours. Is that unique to public interest work, or is that unique to HLab, or how can otherwise people get that sort of quality of interaction with mentors in law school?
I think it was unique to Dave Grossman. Here was someone who had the most elite background imaginable. He was a Harvard professor. He went to Harvard on, just he could have done anything he wanted with his career. But he chose to be a clinical professor and not just sit in a classroom and talk about his old days practicing law, but to really get involved day to day. I mean, if you look, I sometimes go back to my emails from them. We were emailing by the time I was second and third years, at all hours late into the night, early into the morning. I mean, his wife, who I now stay in touch with, and I think would complain a little about how much time Dave and I would be in touch. This was not a vocation for him. It was a true passion. He was a religious man. I think he thought of it as this Jewish concept of tikkun olam, this mission we feel as Jews to repair the world. Dave poured his life into this work. So, there were Saturdays that I missed because I wanted to do. Dave was going every Saturday, with my recollection, going door to door. He had kids, he had a job, and not sort of supervising. He was in the car with me or with another student, talking through what he was seeing, and going to the doors and talking to folks, who were facing foreclosure. He also led for new HLab students a bus tour of Boston, so that people who maybe flew into Logan to go to Harvard, went up to Cambridge and barely left, actually got to see how Boston felt outside the confines of Cambridge and Somerville. So Dave was he poured his life into making the world a better place, but also into making law students, I think, better people and inspiring them as he inspired me to pursue public interest career.
You're saying something that strikes me about, maybe it is specific to public interest work. Cause I remember on the political campaign I worked as a field organizer, which is maybe I would say similar to being a community organizer. And there was, so there's someone who was, a manager, who managed my team. He was an experienced field organizer, and, Glenn Hurowitz. And so Glenn, he wasn't much older than me, but this is kind of the focus of his career. So he had already, progressed a lot. And the thing about Glenn is that he didn't just, he would sit down with us and talk through our strategy for outreach and challenge us, frankly. So, I mean, there would be things like, you know, I would sit down and say, hey, I'm working with this one volunteer. She's amazing. And so, here's the plan for how we're going to work together. I said, great. How many hours is she working right now? I said, oh, she's working, 5 hours a week. Okay. Can you ask her to do 10? So, whoa, Glenn, she's one of my best one of my best, volunteers here. And I said, yeah, I mean, like, those are the people that can give the most. Your best are the people that can give the most. And so there's things like that I learned from him. And that's because he spent a lot of time with granular detail going through my work. But then also he was very willing to knock on doors, get on the phone himself as well. There wasn't anything that was too small for him. I've had a few managers like that have been willing to get into the trenches. But what you just said strikes me that, it's much less common in the practice of law, right? Like, how often does a partner walk into an associate's office and say, hey, let's sit down and look at this document together. Let's just go through these documents together. I think certainly that does exist. But it's way less common. So, yeah. And I don't know if it's specific to public interest or not, but I think that is a hallmark, I think, of a good manager.
Well, I think law, unfortunately, is very hierarchical, and most of us sell our time so that those incentives are not quite right for collaboration. But I will say to the point about you made about working those hours and making yourself known through that. And hopefully there's a lesson here. I was not, I don't think, the smartest or most talented or most generous or, to apply for H Lab or to participate in that project. I think what did set me apart, I think, and what got Dave's interest is that I was consistent. I really came. I told you I didn't go every Saturday, but I went the vast majority of Saturdays as a 1L to do this work. And I went to meetings. These were Tuesday night meetings very frequently. By the time I was in H Lab, I was in court at least once a week, usually more than once a week. So I do think there's great value, I think, in any career people pursue. People put a lot of weight on test scores or how beautiful a brief is, which are all important, but showing up, being reliable, being hardworking, showing passion and commitment. There are trade-offs there in your personal life, but I think in your professional life, is really valuable, as it was for you, it sounds like, on the campaign.
Mm-hmm. And so then, tell me about how you came to work on foreclosure matters as the focus in H Lab. Were there other things you could have focused on? Or was it just the most obvious thing because that's what your first year involved? Tell me about that.
It was somewhat obvious because it was my first year involved. So the way H Lab works, it's different now, but somewhat different now. But back then you had a housing law. Basically it was divided. Half the students do housing law, half the students do family law. And then everyone does a smattering of unemployment, veterans benefits, some other issues. So it was very clear to me I wanted to do housing, and I think they recognized it made sense for me to do housing. The leadership recognized it made sense for me to do housing. There was another divide, interestingly, within the housing group between people doing traditional housing work, which is the rent-paying tenants facing eviction, and owners facing foreclosure. or rent-paying tenants living in foreclosed properties who were facing eviction as a result of foreclosure. Um, and, there were interesting debates in HLAB at the time about, I don't know if people are interested in this beyond me, but about whether it's appropriate to be representing homeowners and in addition to renters, since they often come from better economic circumstances. But Dave and I both had pretty strong feelings about that. And I gravitated strongly toward doing the foreclosure work. And I think, I did some other work. I had other clients who were tenants. I did an unemployment case. I did some other stuff, but the overwhelming majority of my docket was foreclosure. And I represented many, 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 many clients. I don't know the number, but certainly more than 20, probably more than 30 or 40 clients facing foreclosure. Facing eviction as a result of foreclosure.
And so there was a path to you getting some really unique experience and actually some groundbreaking experience in this role. What was that path that led you to what was the outcome, if you want to give this fuller now, and then what was the path that led you to that?
Well, we as a law clinic, and I certainly played a role in it. I mean, we changed Massachusetts law pretty significantly to make protections a lot stronger for people in foreclosure. Before I joined the clinic, HLAB brought one of the first cases, I think the first case, establishing that you can challenge a foreclosed. So we have some lawyers listening, I presume. The way it works is that you can foreclose without judicial process. So you can change the ownership from the homeowner to the lender or to whoever buys the property at auction. But then you still need to take someone to court to evict them, to gain possession of the property. So we brought one of the first cases and I went to the state Supreme Judicial Court, establishing that the validity of the foreclosure itself could be challenged at the eviction stage on the straightforward basis that if the foreclosure wasn't legal, it was void, and the subsequent owner had no right to evict the previous homeowner. When I was there, the big question was, and for those who looked through this might remember, when you own a property, there's a note, which is the loan, and there's a mortgage, which is collateral on the note. That's the right to the property. Massachusetts law at the time, as it was being applied by the courts, was that lenders did not need to establish that they held the note in order to pursue foreclosure and eviction in order to hold a foreclosure auction and pursue an eviction action against homeowners. We took the position in case after case that was not true, that you needed to show that you had a beneficial interest in the note. And we ended up winning the first ever in the state preliminary injunction against proceeding with an eviction on the basis that Fannie Mae could not demonstrate it held the promissory note. That case was quickly appealed by Fannie. I should add, by the way, Fannie Mae at the time was in government conservatorship. So this was us, law students representing low-income homeowners against the U.S. government. Pretty shocking if you think about it. But anyway, Fannie Mae appealed the case. The Supreme Judicial Court ended up taking it sua sponte. So it didn't even, I think it was briefed at the Court of Appeals, but the SJC grabbed it because they realized the big implications. And I had the really unique opportunity at the beginning of my third year to argue a case before the Supreme Judicial Court. We could talk about how that went, but it was an incredibly unique experience. It was honestly just one way that working with legal aid providers all over Boston, I think we really transformed the experience of people facing foreclosure. We designed model answers, model briefs. We set up Lawyer for the Day programs. I mean, it was a really multifaceted effort to strengthen protections for homeowners, and also on the sword side, fight for legal change at the legislature.
I mean, operationally, how did you manage this? Because on one hand, you're taking, you have to focus your attention on this legally novel position and make sure this is well briefed and be prepared for taking this to the Supreme Court. And it's kind of like, like this very focused effort. On the other hand, you're focusing on scaling your efforts to make it replicable for other people to do this as well. How did you manage to balance both those needs?
It was a incredible model that you can't do in every court. So Massachusetts Housing Court allowed limited assistance representation. You could show up for a hearing and then you enter an appearance and then withdraw your appearance, or you could keep your appearance through. There's flexibility around it. Which, by the way, I'm a big believer in, because it allows, there are never enough lawyers to help low-income people in court. This allows us to expand our scale. So what we would do, and I was often the one doing this on a Monday, we would go down to the housing court in Boston and we would get the list of all the people facing eviction on Thursday. Thursday was eviction day when all the cases were being heard. We would reach out to those people. I think the Monday was maybe the subsequent week. I don't remember the exact time. We would get the list on Monday. We would send them letters encouraging them to come to City Light and encouraging them to find us in court. We would also try to find them at the organizing meetings on Tuesday night at City Light. And for clients like that, who I got to meet early on in the process, like this case I brought to the Supreme Judicial Court, I met that client through City Light. So, I knew a lot about her. Her name was Henrietta Eden. We worked together. It was a more traditional form of representation. But the other thing we did is we had those names on Monday. On Wednesday night, the day before court, I would look up public records of their foreclosures, because this is all in their, recorder of deeds. Their foreclosures had already happened, remember. They were now facing eviction. And I would see if I can spot some problems. Maybe I knew that this particular mortgage trust had a history of illegal evictions. Maybe I saw, and these are all real examples, maybe I saw that a signature on that a power of attorney on a foreclosure deed had expired, which under Massachusetts law renders a foreclosure. But I would look for issues in their foreclosure. And I would go to court the next day, and it wasn't just me, it was a group of us, and we'd hear people's names called at the beginning of the hearing, and we would try to corner them and see if they would want representation. Now, a lot of people, most people, or many people, did not even show up. They got defaulted, which we really tried to prevent, but that was a real struggle. But there were a lot of clients we met on the courthouse floor where I got up or my colleagues got up, and we represented them, having met them 15 minutes before. And the extent we saw their case file was like whatever manila envelope they brought and whatever we had seen the night before on the recorder of deeds. So it was, this is not how a federal court, usually operates, but this is how things work in eviction court. It's not, as I said at the top, this is not the type of lawyering you learn in law school, but this is the type of lawyering that made a big difference in slowing down a mass displacement machine that would have otherwise been going at full throttle in Massachusetts.
And so then you took this matter to the Supreme Court and you argued it and you prevailed.
Well, it was interesting. Could I jump in on this?
Yeah.
It was, we argued it in October. In December or January, the SJC, Supreme Judicial Court requested supplemental briefing on whether, if they ruled in my client's favor, it would have a sort of cataclysmic effect on the housing market in Massachusetts, because it would cloud title on all of these properties. We argued very strongly that, title insurance that can deal with that. These companies shouldn't get a break just because banks broke the law at scale, doesn't mean they should be unaccountable for breaking the law. But what the SJC did, pretty interestingly, when they issued their ruling, they ruled in our favor, but they made it prospective only. It's set with respect to my client. So they ruled that my client and Fannie Mae needed to show the note. Foreclosures going forward, they needed to be proven, but had no effect retroactively, which, I think it was another lesson for me at the kind of power large financial institutions have in our economy when they can break the law for years and have the SJC recognize it, and they don't have to face the consequences.
Hmm. So, what was the aftermath of arguing? So you had a mixed victory, but certainly a victory.
Yeah.
Then what? What for you professionally? Then what?
I continued my work. I wasn't going to sit around waiting for the argument. I would, I mean, one effect on my casework. I mean, it was wonderful. Like we would go it, for months while that decision was pending. At least in the court I was practicing, evictions were not happening because every case I would go up there and I would say, "Well, you can't rule on this until the SJC rules in the Eaton case." These evictions were not moving. We kept people in their homes for many months, just through that case being pending. But I continued the work. I did a jury trial my second semester of my 3L year. And that was actually a more traditional tenant case, also against Fannie Mae. Not very coincidentally, actually, but Fannie Mae had subjected my client to some horrible conditions in the apartment that she rented. We took that case to trial. We brought two counts. We won on one. We lost in the other, but we won. It was a positive outcome for my client. So I stayed very busy throughout that year.
Well, what did it feel like? Okay, so you're just like lost.
Yeah.
And on one hand, you're doing this very grubby work. It's just like
Yeah.
you're just like very manual. You're walking up to a total stranger saying, "Can I represent you?" Any number of times you're probably getting rejected or just like, "What is this? Who is this weirdo? Like, what is this?"
Yeah.
So just thankless could be one word to use potentially, but just difficult work. Okay, so you're doing this difficult work, grubby work, whatever. And then you have this impasse where like, okay, like there's this Supreme Court decision pending before it's even resolved. And, I'm assuming it's a rotating number of judges, but they probably know who you are at this point. And you're saying that everyone's case is, well, judge, and you can't rule until this decision's resolved. Even at that stage, you had to be feeling this enormous amount of power of some kind. Did you feel that, and what did it feel like?
Well, by the time I argued the case and afterward, it was pretty surreal, honestly. I was, Katie Porter was a law professor at the time. I worked with her on the case. I had been interviewed in the Wall Street Journal and Bloomberg. NPR did a story on it. Matt Desmond, who went on to write Evicted, came to shadow us in housing court and speak to our class about the research he was doing. By 2010, 2011, there was a lot of more attention on this issue. There was a lot more recognition of what was happening on the ground. And for me, yes, there was more recognition of I think what I had and my colleagues had been able to do. But I will say, as a second year law student, I didn't have any of that. But what I did have, which I think was more fulfilling and more important, my first time appearing in court. So this was, I guess, I don't know, beginning of my 2L year. I mentioned to you that City Life sent organizers to these court hearings. I got up and I made, I was a high school and college debater. I made an argument the only way I knew how to make. I made a really impassioned argument for why not holding a note and these other issues were not just technicalities. These were illegal foreclosures that my clients had suffered a great injustice. And I did not win that. I mean, we ended up getting a continuance. I didn't lose it. I didn't win it. But when I turned around, this is my first time in court, a group of people from the organizing meeting stood up and cheered. Now, again, that is not why I did it. That is not, if anyone's going into law so they can show up in court and get cheered after they sit down, they should find another profession because that doesn't happen very often. But it was deeply fulfilling to me because what it made me feel like, and this is how we consciously talked about it, is I was not just representing one client. I was trying to represent this movement, this organization. And again, I can't emphasize enough. This was not just me. I had many colleagues, including my colleague who's at the FTC now, Jen Tarr, right there with me, and many others, fighting for people. And to actually have that reaction, again, it meant a lot to me. A, because I was really nervous. I just stood up in a courtroom for the first time. But B, because it really made me feel like I was part of something broader than one case or one client. I was part of a movement to try to restore some measure of economic justice for people who had been denied it.
Mm-hmm. So then how did this direct your career? So you've had this extraordinary beginning of a career, um, potentially even distortingly so. How did you make contextualization for what comes next and what you could expect out of your career?
It took some twists, in 2012, and I know you know this, like the job market was not great. But by that time, if you were going to a good law school, the job market at top firms was pretty decent, but it was pretty tough for public interest law. And I had a good, I had a good record in law school. I had good grades. I had done interesting things in the clinic. So I think I was a strong candidate, but getting a public interest job was tough. I originally thought I wanted to do legal aid because it was what most resembled what I was doing on the ground at the clinic. I ended up having a choice between doing, I did not get every job I applied for at all. But I ended up being very fortunate to have a choice between doing a 2-year legal aid kind of fellowship in Chicago or going to the Illinois Attorney General, which at the time was on the front lines of trying to negotiate the national mortgage settlement with the mortgage servicers. And because I had done legal aid work the summer before, and had obviously done a lot of legal aid work in Boston on foreclosure work. When I was interviewed at the Illinois AG, I remember sitting down with people like Debbie Hagan, who was the division chief, Shali Rao. These were people like me who geeked out on mortgage law and foreclosure law. And I got to geek out right with them, which probably they were not used to in a law student. I knew some of the same advocates they knew. I knew the issues. I knew, we worked in different states, but we can really compare notes in a substantive way where I felt, even though I was a third-year law student, I was not a peer, but I had a conversation with them at that level. Like I was not coming to this being like, I'm totally green. You should take a chance on me. It was, no, I have a track record of keeping people at their homes and fighting illegal foreclosures. So I think that put me in a good position to work for the Illinois AG, though I have to tell you what Dave Grossman told me, which is that I think he wanted me to work in legal aid. He said, you're going to work for the man. And I reminded him that the AG, Lisa Madigan, was a woman, in fact, and was a real champion for consumers. But he ended up coming around to it, but it took some time.
So he just wasn't believe. I mean, in the state AG process, like he just felt like that was like captured by big business interests or something.
He didn't say that, but I think he was a movement lawyer to his core. He was trained by and mentored by Gary Bello, who was he was a lawyer for Cesar Chavez and a leader at Harvard Law School, in the clinics. And Dave really was a believer in ground up change and people power. I had more of an open mind about government than Dave did. I toward the end of his life, I tried to convince him. I'm not sure I ever did, but I mean, look, he was certainly pleased I was doing public interest work on behalf of consumers. But I think his ideal always would have been, legal aid on the front lines, and I can certainly respect that.
So then paint a picture for, was there anything that you directed in your course of work at the agent's office? Like you had such an active role in the kind of work you did at HLab. What level of activity were you able to have with directing the kind of work you did at the AG's office?
So when I started at the AG's office, I hadn't even passed the bar yet, right? It was September of 2012. So I was still waiting for my bar results. Fortunately, I passed the bar in October, but they put me right to work. So part of the context here is I came on to work on the mortgage settlement and mortgage work. But by the time I joined, the mortgage settlement had already been entered. The office was needed me in other places. And what I ended up working on was a problem that felt eerily parallel to what I worked on housing, which was for-profit schools. Predatory for-profits, sometimes publicly traded colleges and universities. And I can talk about what that looked like in a minute, but the the interesting thing about being at an AG, which I tell people all the time, is the AG did not have the luxury of having me sit in a corner doing doc review. I started appearing in state court, I mean, within days of, I mean, literally days of my passing bar. I was in, another great thing about state AG work was you're in state courts. State courts tend to have more hearings than federal. I was in court a lot. I was taking depositions. I think I took my first deposition as like a real lawyer. I think it was before the end of the year. So I started in September. I think I took that. I'm not sure of that, but it was very early on. I started taking and defending depositions. So, and again, I think part of it is because they saw some talent in me and some potential, and I had some real experience from H Lab. Part of it's just like these are small offices doing big things. They need every person they can get. They can't afford to have someone just sitting in a corner. So it's a wonder, the pay is not good. It wasn't then, isn't now. But if you want to get actual experience as a lawyer, it's a wonderful place to work at a state AG.
And then what led you to leave the AG's office to clerk?
So the AG's office was an incredibly fulfilling experience. If I could, a brief digression about some of the for-profit school work, because I think it's telling. I described the mortgage foreclosure work as seeing sort of lenders telling people this is the path to the middle class and this is houses are sure things. We heard the same thing from for-profit school operators. And just as in the foreclosure context, the federal government, I felt, was asleep at the wheel when it came to stopping predatory lending and helping homeowners who got caught. I felt the same way about for-profit schools, about the Department of Ed needing to do a lot more to hold these schools accountable. But by 2014, 2015, we were really seeing a change in the Obama administration. Department of Ed was beginning to do, I think, serious investigations of for-profit schools. They were working with us. They were moving forward on some very important rulemakings, one of which I participated in. I kind of felt that we were winning, things were going well. Some of the biggest chain that I was interested in, Corinthian, actually, I think collapsed in 2015 or 2016, as did ITT, two of, I think, the worst operators in history. And I felt it could be a good time to move on and do similar work, but at the federal government. I was interested in being in federal court. I was interested in a salary that was a little more manageable than state government. I mean, the pay differential was really dramatic. I was interested in challenging myself a little more. Problem was I had very little experience in federal court. So what I was told by some folks who worked in the federal government was go clerk. That's how you get experience. I mean, you go to a law firm or you can go clerk. So I applied for a clerkship. I applied only in Chicago. I figured if I don't get a clerkship, I'll just keep on working at the AG. That's fine. So I wasn't desperate. I applied for clerkships in Chicago, and I was lucky enough to find a clerkship with a really legendary judge, Milton Shader.
So I appeared before Judge Shader.
I'm sorry.
Yeah, one of the most remarkable judges that you could ever appear before. And at the time, I think he was already maybe 90 when I appeared before him.
Right.
And I don't think it's another judge that has all these like little trinkets and tchotchkes like on the desk of like old timey antique stuff that I never knew the significance of.
Yeah. And dolls. Yeah.
Yeah, that kind of stuff. But I think what really struck about him is he was such an independent thinker. He would, challenge just like things like, if you, had an answer to a complaint and, he would challenge like, what do you mean by information belief? Like
right.
What information you have? What is your belief? Like you can't
He was a Rule 8 stickler.
Yes. So, he was very anti anything formulaic and really challenge you to think hard and long about, what you're putting into, what objections you're putting into, responses to RFPs or just any of that stuff. So, he was remarkable in that way, and I wonder what impact he made on you.
he was a remarkable judge. He passed away in, I think, 2017. He was maybe 94 years old. I mean, the man's career is legendary. He enrolled, I'm going to get this wrong, but he enrolled at the University of Chicago Law School. I think he was like 90, something very young age. I think he became the youngest ever partner of a prominent, smaller but prominent firm in Chicago in the early 50s. One of his partners was Arthur Goldberg, who would go on to join the Supreme Court, become UN ambassador. He represented Adlai, if you're a political history nerd, Judge Shader actually represented Adlai Stevenson, who was the Democratic nominee for president in 1956 and 1952. So this gives you a sense of Judge Shader's history. He went and he was appointed to the bench in 1979 by President Carter. So he had deep experience. I think he was a very principled, but also very pragmatic judge. He was old school, both in terms of his, real stickler on the rules, did not like shortcuts that lawyers like to take, for example, in filing answers. He would routinely dismiss cases before I even got to the office, because of some deficiency in the pleading. But he had a real strong sense of justice as well. We would have conversations. I don't think I'm revealing anything inappropriate. He of course would always follow the law, but he was a person too, and had a sense of what was just. And, he was not afraid, to strike independent positions. He was not afraid to take unpopular positions, which he sometimes did and got a lot of attention for it. He was a real believer in, he loved being a district court judge. He loved being a trial judge. And I think it was a real loss to the bench when he passed away, or when he first stepped down and then passed away. For me personally, I both got to know the federal courts better and how they work, and it's not that different in the rules than state court, but it feels very different than at least Illinois state court. He also I think I was a good writer. He made me a much better writer. Judge Shader was a very good writer. And one thing I slowly got better at was learning to capture his voice. And I've actually incorporated a lot of it into, he had a rule. You could not start sentences with "the," which was annoying as hell if you're trying to write a long opinion. But it forced you to use variety in your syntax that ended up making opinions a lot. Now, of course, he let himself break his own rule. He didn't really let his clerks break his rule. So it forced you to be really imaginative in your syntax, and it made you read any of his opinions, from a short order to a lengthy ruling on summary judgment. There's a real verve in his writing, that's both deep and scholarly, but also a pleasure to read, and very funny sometimes.
Yes. So from there, so you burnished your standing in federal court from this experience, and then how did you figure out what came next for you from there?
Well, it was natural. I was a consumer protection lawyer at the Illinois Attorney General. My job was enforcing Illinois' mini FTC Act, the prohibition on unfair, deceptive acts or practices. So, so I wanted to stay in Chicago, but I basically wanted to go to a consumer protection agency. So there aren't that many. I looked at CFPB, I looked at FCC, and I looked at FTC. FTC was my top choice. And I got very, very lucky, that they had a job opening and that they took a chance and hired me. But I had, it was my dream job. I was very excited to get it.
You did some advocacy to make this happen, though. You weren't.
Oh, sure.
Yeah. So what is it that you did?
Sure. So, when you apply for any federal job, you go through USA Jobs, which probably has not gotten easier since I applied a decade ago. Your resume goes into a little bit of a black box. You don't really know what, even now that I'm on this end of it, I don't always know what's happening at the USA Jobs level. But I reached out to Harvard, And I have to put in a word for Harvard's Office of Public Interest Advising, led at the time by Alexa Shabakoff, who was assistant dean of the law school and was an absolute force of nature. Even though the job market was not very good for public interest students, Harvard offered extraordinary support for students looking to pursue public interest. I mean, I had Alexa and Judy Murciano and others on speed dial. They knew everything I was applying for. I mean, we were we still are friends to this day. That was the kind of relationship I had with my career advisors. So I was very lucky. And when it was time for me to find a job, even though I was a couple of years out of law school, I did not hesitate to reach out to Alexa. So I reached out to Alexa. Alexa connected me to someone else in her office, Catherine Patanayak, who does federal hiring. She did not know anyone at the FTC in Chicago, but she knew another HLS grad at FTC headquarters, someone I work with closely now, Tara Koslov, who's deputy director. Tara connected me to a lawyer in the Chicago office of the FTC. So, Harvard really went, and every law school I hope is doing this, above and beyond. They didn't have a connection, so they found, in fact, I think there was one more degree of separation there. They just kept persisting until they found a connection for me. And then for me, it was easy. I got coffee with Joni Wade, who's a staff attorney at the time. Now she's assistant director in our Chicago office. Talked through why I was interested in the FTC and my experience. And she put in a word for me to the director at the time, Todd Tasso, just retired. So, who knows what would have happened if I hadn't done that? I'd like to think they would have found my resume in the stack. But I was able, through my law school alumni work or connections, to find a human face at that office that I'm sure helped me land that job.
And then from there, you had some advocacy that led you to work for then Commissioner Rohit Chopra as well.
It was a little bit, it was not advocacy at the FTC, actually. What happened was when I was at the Illinois AG, and I told you that we were struggling to get the federal government to pay attention to for-profit schools, with one exception, and that was the Consumer Financial Protection Bureau. The agency that Elizabeth Warren, who was a law professor when I was there, had her brainchild. CFPB had a very energetic young student loan ombudsman named Rohit Chopra, who really was working, I think, on two fronts. He wanted to put student debt on the national agenda, and I think he, working with many others, succeeded. And he wanted to make sure for-profit schools that were breaking the law were being held accountable. And for that, he worked closely with coalition of state AGs. I got to know Rohit through that work. I would fly to DC not infrequently to meet with him and other CFPB and state officials about our overall strategy on these different cases. So when Rohit was, we went our separate, he ended up going to the Department of Ed. I ended up going to the FTC. We stayed in touch. To my surprise, well, by the time it happened, I wasn't surprised, but he was nominated to be an FTC commissioner in, I believe, 2017. And I actually did something that took, it was hard for me to do. It did not come naturally to me, which was reach out to him and see if he'd be willing to hire me as an advisor.
What was the impact of that? Like, what did that teach you about reaching out to him?
I'm someone who is always afraid of sounding or being presumptuous. To this day, it's something I struggle with. I think a lot of people probably do, but it's certainly something for me. And the notion that, I knew Rohit, I thought he respected me, but we didn't, he wasn't reviewing my briefs in Illinois. Like, he wasn't firsthand reviewing my work product. He's not even a lawyer. Like, we were not co-counsel on cases together. But I knew him pretty well, but I didn't know if I knew him well enough. I mean, he at the time was a pretty prominent figure. Now he's prominent generally. Then he was prominent in the student debt world. I thought he could have the pick of any consumer lawyer in the country for this job. Everyone saw him as a rising star. So I felt for me, who is, I was in Chicago, I wasn't even in DC. I had been at the FTC for a short time. To me, to ask to be this, pretty important role as an advisor to a commissioner felt like I remember thinking to myself, well, I have nothing to lose. There wasn't that easy. I had to really convince myself and talk to people. And I really had to kind of, steel myself to reach out. And, um, I did. And I think something out that was like a trial period. I would go for a 3 to 6 month detail. We would see if it worked out and see what happens. That required me to pack my bags and move from Chicago to DC, but I had the good sense to, I wasn't married. I wasn't tied down. I think I had the good sense to recognize this was an opportunity I should take. And I did it. I moved to DC. Never thought I would move.
What then? I mean, how do you leap from attorney advisor to director of the Bureau of Consumer Protection?
Well, the first thing was that Rohit took a chance on me and brought me on as, still a relatively junior attorney, to be his only consumer protection. I was his consumer protection advisor. On legal, he had a technologist as well on chief of staff we worked very closely together. But basically every consumer protection case, I was working with him. There was a big responsibility. So he really took a chance on me. And he also took a chance on another young legal fellow. She became a legal fellow who had just graduated law school, had gotten some attention for a law review article she wrote in 2017. Rohit hired her for the summer. Her name was Lena Khan. Lena at the time I think people had heard of her article. I don't think she certainly wasn't the figure she is now. But she came in and worked as a legal fellow with Rohit. They were working on a law review article together on unfair method of competition rulemaking, which is a hot topic these days. And I got to know Lena. And one of the things the day I met her that I learned was that she had also done a foreclosure clinic in law school. So she had sort of that same experience as I did, witnessing how the financial crisis was affecting real people. So long story short, Lena just stayed for a few months. Then she went to Columbia to be a law professor. Fast forward a couple years, President Biden is President Biden by this time. He's been elected president. He nominates Lena to be an FTC commissioner. She is confirmed. The day she's confirmed, or maybe the day after, he names her chair of the FTC, which is the head of a 5-person agency. She's the head of it. And she appointed me a couple of days later as an acting director of the Bureau of Consumer Protection.
Then what happened? What was that? What was the process like from going from acting director to director?
Well, the process of going from acting, it was an enormous leap from the advisor position to the acting director. The leap from advisor to acting director was much bigger than the leap from acting director to director. The leap from acting director was to director. It was a mindset shift. It was like, okay, I'm the leader of the bureau now. But it was mostly paperwork, right? I became a political appointee. There were a lot of additional financial disclosures I had to complete. The commission votes on my appointment, and I, sort of sat down for interviews with, it wasn't like a job interview, but I sat down one-on-one with each commissioner to talk through my vision for the bureau and my vision for how I would work with them. And then they voted, and I was pleased to get a unanimous vote, to be named, the director of the bureau, which I remain.
So then in that leap, to talk about that first leap from attorney advisor to this acting director, what had to change for you? You were in that role for let's say 3 months or whatever. Like, what was the biggest surprise in that transformation?
The scale of the responsibility was a little overwhelming, honestly, for me. Um, it would have been, as an advisor, I had a, I had an unusually big job for an advisor. Most commissioners have two consumer protection legal advisors. Rohit had one. He also, as I said, had a outstanding technologist, Erie Meyer, and others, but he only had one attorney advising him on consumer protection. So I had a large volume of cases. I had to learn about a lot of FTC law. I had to learn how the FTC, remember, I had been in Chicago, so I didn't know a lot of this. I had to learn about the organization, I learned the managers. So I came in with a lot of advantages. Like I knew the managers of all the offices. I knew the substance. I knew the kinds of cases, the rhythm. I knew how cases got out of the commission. I came in with some real strengths, but I had not really been a manager before. And suddenly I was managing a group with, 450 people. Um, Rohit had sketched as a minority commissioner during the Trump administration a very ambitious agenda for consumer protection. Sort of, if you think of him as like a shadow government, like what the vision that he laid out when he was in the minority, I felt, obviously my job now would be to carry out Lena's vision, but I felt expectations were high about what we'd be able to deliver. So that was very, the size of the organization, the ambition that I know Lena felt, that Rohit felt, and the trust that both of them had placed in me. Getting to know the people. Many of the people sort of in the front office that I became the head of, I didn't know very well, or I only knew from a distance, and getting to know them, figuring out how I wanted to staff the office, figuring out how I wanted to order. These were all totally new experiences for me. And I had to learn on the job.
Was there something remarkable about being in this org? So, Rohit Chopra, I think he's like 42, young.
Yeah.
You're young as well. Late 30s, right?
Yeah. 38.
And Lena Khan, of course, is also young as well. Like, was this historically novel for so many young people to have such leadership roles in these key parts of consumer protection?
In recent history, yeah, I think it is. And I don't think it's a coincidence. I think Rohit, Lena, and I, and Erie Meyer, many of the people I worked with, we were shaped by what we saw in 2008, 2009. We were inspired by Elizabeth Warren. We were excited by the notion with the CFPB that the government could play a bigger role in protecting the public. Obviously, Lena came in with her own antitrust perspective, which was not my world, but I quickly became interested in. So, we grew up in this sort of Reaganite orthodoxy that government that governs best governs least. Government should stay out of the way. Markets should be trusted themselves. In particular, government should deregulate the financial market, with both President Clinton and President Bush supported and contributed to. And then suddenly we graduate college and we're hit, and all of everything we learned, and this culture, turned out to be wrong. The deregulation was a disaster. Everyone said we're in a free market, but here these banks are getting these massive bailouts. Everyone says the law is supposed to apply equally, but none of these bank executives faced any consequences. So I think all of us came up and were shaped profoundly by the financial crisis. And it really motivated us, each one of us in our own way, to believe that we need some big changes in how the government sees its role in protecting the public.
So I think an interesting aspect of your career to explore is, it's been very bottom up, and it's not been very highly strategic. Like, it's not been, someone might look at your resume and say, okay, well, you don't accidentally end up as director of Bureau of Consumer Protection, obviously. So like, you must have been working backwards in some way to make that happen, and you had the right pedigree to make it happen. So everything was in place to make this happen. So I think we've got a clear counter narrative for that. But tell me, in choosing these experiences, I don't think you could use the word strategic as like, hey, this is a strategic, I'm going to join H Lab because that's going to be better for my career than law review, or in H lab, I'll take on this kind of work because this is most likely to yield me, getting in front of court. There's some mild strategy involved with, hey, if I want to get into, a role in federal government, clerkship will buttress that. And so there's some strategic aspect to your career, but largely it's been bottom up. Can you say a word for the merits of a strategic approach to career? Do you have a strategic approach to career now, or is there some way that you can encourage students to have a strategic approach to career? And then I definitely want to hear about ways in which people can be more bottom up, but I thought I'd start with that.
I think one thing I did, and I'm not sure it was strategic at the time, but in retrospect, I'm going to call it a good strategy, I guess. I did not chase prestige, which is a trap I think a lot of people, especially people who are at elite law schools, fall into. But when you do well, I did well in high school, I did well in college, you're used to getting a certain level of validation from elite institutions in the form of grades or recognition or the like. And then many people who are in law school then leads them to pursue law firms because it sort of resembles the hierarchy that they experienced when they were applying for laws. There's a ranking of law firms and they'll interview you and you get a very nice office and a nice pay and it's very fancy when you say you work somewhere. I did not chase prestige. I chased experiences that were fulfilling to me and where I felt I could do good. And I don't just mean do good for the world. I'm not saying it was totally altruistic. It was also like do good in like work that I like and care about, work that I can do, work for hours and hours and still enjoy. So, I'm not sure I would have made law review if I had applied, but I was not interested in law review. I hated blue booking. I found law review. I mean, I'm now proud to have published a law review article, but I'm actually not that interested in writing law review articles. I'm working on another one now, but I'm not that interested in working on law review articles. I wanted to practice, so I pursued the Legal Aid Bureau. The summer internships I did were one was at a legal aid group, the other was a public interest organization. Illinois state government is not, it's many great things. It's not particularly fancy. I worked in a really now condemned office. The experiences I think mattered to be more when I applied for clerkships. I said I applied only in Chicago. I applied for district court and Seventh Circuit. If I had gotten a Seventh Circuit clerkship, I probably would have taken it, but I actually wanted district court because I thought that would get me better experience. Again, I was not going to turn down a Seventh Circuit clerkship if someone was going to offer it, but I wanted the experience of being in a district court. And I think that was a good idea because I do find, and I have many, many examples, that people who chase prestige, there's nothing wrong with prestige, I went to a fancy law school and know, and the fact that it was prestigious certainly played a role in my going there. So there's nothing wrong with prestige, but when you graduate law school, you have to think about this is the rest of your life. This isn't like a stepping stone. It's a stepping stone, the next thing, but you're also like this, you're setting yourself on a path, and chasing prestige does not a fulfilling career make in the long term. I think if you can go in law school and find something you like to do and use law school to figure out what you like to do, chase that. And then I think the recognition and the job opportunities hopefully will follow because you'll be good at it.
Yeah, I think that's definitely helpful advice. And I think that maybe to build on that advice or how you can additionally frame it. I think some of the challenge that you see with a lot of people in big law is I think they, like any of us, I was in big law for very similar reasons of the status of prestige, but then also the narrative you can tell yourself is, oh, well, I can leverage this for whatever else I want to do. So I can, I'll have money that I've stocked away, that also I have this prestige and, probably good experience. So then that will be the ultimate jumping off point. So how would you address that?
That is true for many people. I think I know for many more people, I'm not sure that is true. There are a number of issues with it. First, a lot of people go to law firms and just burn out. really quickly and they just leave the law. And I have a number of friends who just left the law altogether. Um, Others go to firms and maybe they can tolerate it, but they're not getting great experience. So when they apply for, say, they want to be a U.S. attorney or assistant U.S. attorney or something like that. Like a lot of people say they go to a law firm and then they go into government, but yeah, you're the FTC. We get a lot of applications from third year, fourth year law students. You're in the U.S. attorney's office. You're getting a whole lot. And if you're not getting that experience law firm, it's not a sure thing you're gonna get a job at a U.S. Attorney's Office. What you often see instead is people going from one law firm to another law firm with maybe less prestige, but also better hours. And that's a totally reasonable career path. But if the goal was to kind of parlay the prestige of a law firm into something you really want to do, whether that's government or nonprofit, that is not a sure thing. And you're really somewhat, I mean, you would know this better than I do, but from what my friends tell me, you're somewhat at the mercy of what partners you end up working with, what work you end up getting, what cases you end up being on. So it's a risky proposition. People think of it as the lowest risk option. I don't think it's the lowest risk option.
What would you say is the lowest risk option?
Yeah, as I said that, I thought, well, what is the lowest risk option? I mean, the lowest risk option is a privileged one that not everyone can do, which is to find something you like to do. Look, and I'm not delusional about this. Not everyone has that opportunity, but what I would encourage people to do is be open to jobs that are not the most prestigious. Especially, I mean, I saw this at Harvard Law School. It was like you either go to a big law firm or very fancy public interest group like ACLU. If you went into government, it was usually the DOJ, being an assistant U.S. attorney. There were certain career paths that were sort of associated that were sufficiently prestigious for Harvard graduates. People should look beyond that. People should look at local government, state government, legal aid, which many people do. So I think the safest path is if you can find something you like and you're good at, pursue that. And then hopefully you'll succeed in a way that you can stand out in your career and go on to bigger and bigger things.
Okay, then let's be more specific. Let's say you're a fifth year associate at a big firm trying to figure out what comes next. And this fifth year comes to Sam Levine and says, Sam, I'm trying to figure out what comes next here. I'm trying to incorporate the principles you're talking about. How would I apply those? I mean, I'm 5 years in, I'm at a big firm. I have experiences that I have. I'm somewhat specialized. How do I figure out what comes next for me? If I want to pursue your thesis of being more intentional with experiences and finding things that you love.
Well, it's a question of whether that person knows what they want to do. If it's something that the person knows they want to do, there are opportunities. So obviously, the first thing is if you're able to do that through your job at the law firm, that's great. Again, I've not worked at a big law firm, so I don't want to speak to what the dynamics are, but certainly if you're able to find a partner who can give you opportunities to do the things you're interested in, getting some real experience in that is going to be really important. If you can't do that, I mean, one thing I did when I was at the AG, and I guess this was strategic on my part. I joined the local bar association and became co-chair. At some point, I became co-chair of the consumer law committee at the Chicago Bar Association. And what that allowed me to do, and one reason this was strategic is it allowed me to keep my toe in the consumer protection water, even while I was clerking. I made sure that this was kosher to do this, of course. So I became co-chair of the committee. And, it was the nice thing about it, if we're talking being strategic, is people I wanted to meet, I would invite them to speak to the Bar Association. I wanted to meet people at CFPB. I would hold a thing on what's going on at the CFPB. I remember wanting to learn about privacy, and I invited Jay Edelson to speak. There were other opportunities. I was also involved in my alumni organizations. there are other opportunities outside your law firm to try to get involved. Where oftentimes these groups like local bar associations, they often need people to volunteer, to do kind of the grunt work of organizing speakers, tracking CLEs. Like if you're willing to do that, it's a real way to gain experience, exposure, and connections, even if you're not getting those in your day job.
Is there anything intentional you're doing with your network or similarly with developing your um, expertise, either of those at this stage?
At this stage, it's something I probably should do more. I mean, the reality is, I mean, I'm fortunate. I do a lot of speaking events and conferences, and I have lots of meetings. So I get to meet a lot of people in the course of my work. But the reality is the hours in this job are very, very demanding. And it's hard for me. Like at the end of the day, I might have an event after work. And by the time I'm done with many, many hours of work starting at 6:30 a.m., then you have an event after work and you got to eat dinner. You want to see your partner. You want to relax. Like you don't want to then go to some other networking event or, so it's a challenge for me. It's something I probably should be more intentional about, but I'm very sympathetic to people who say, look, like that's all sounds well and good, but I'm working crazy hours. I don't have time. And not, I, I feel a lot of empathy there.
So, okay. So going back to you're talking about when you gave that first whole argument, and there's a group of people behind you that, you know, literally cheering you on.
Yeah.
And so, as you said, pick this path for, for that public validation. But of course, we're human beings. And of course, it's helpful and satisfying, gratifying to get that. Um, I think something interesting about your role is how public facing it is and how much, and certainly there was, I haven't heard anything about media strategy that you used earlier on, but maybe I'll pause there. Like, was there any kind of, going back to H Lab, you mentioned you got coverage. Was there a media strategy component to that work that was intentional?
There was a media strategy, which it's interesting you asked that. I was not, I don't do that here, even though we have a public affairs team, and I didn't do it in law school. I don't think we really had a strategy. We had reporters come to us, but I did through that experience it was my first real exposure to the media. I started doing interviews for the first time. I remember I had a reporter from The Nation shadow me on a foreclosure when I was going door to door and ended up doing a cover story on our foreclosure work. I did a fair number of interviews with reporters at both local and national publications. One thing I did realize is, I was pretty good at that. I did forensics in high school. I did debate in high school. I did forensics and debate in college. Like I've always enjoyed public speaking. I always enjoyed oral arguments in court. And I will say one thing I have tried to do in this job is to try to use whatever skills I have there to be, especially when I was starting, I did not have a lot of management. And, there were a lot of things I lacked. But one thing I really tried to do is I could be a good voice for the Bureau, a good advocate for the Bureau. So that's something I've tried to use both because I think media is an important part of achieving social change. I think some lawyers dismiss that, but they shouldn't. But also because I wanted the Bureau to feel the people who work in the Bureau of Consumer Protection to feel that I was a good voice for them and a good advocate for them. And that's something I've tried to do, my whole 3 years in this job.
Can you say about, a little bit about another way of affecting this change could have been through private practice, through, consumer law. And so have you ever thought about, what would my career have been like if I went down that path?
I didn't really think well, there were some opportunities I was considering on, private public interest firms. I have not thought about it a lot. I can tell you that we have been able to recruit at the FTC a number of lawyers from firms like Cohen Milstein who have real great experience in affirmative public interest litigation, and they are top notch. They're creative, they're aggressive, they're good. They're good colleagues. I don't want to say this about every person out there, but they bring a certain spirit of I want to say aggressiveness, I think, and willing to not afraid of a fight that I really admire. So I really see the work of public interest law firms as complementary to the work of the FTC. I think we're often fighting for the same things. And certainly when we're hiring, people who have those backgrounds, it's very compelling, in terms of how that sets them up to succeed at the FTC.
You consider them complementary. Is there anything that makes someone more suitable for one path than the other?
In the sense that makes a lawyer more suitable for a uh, private firm versus the government.
Yeah.
I think it depends on what people want. I mean, obviously, one part of working in a firm is, I mean, at least what I was told in law school. I mean, the hours are often not any better than a defense side firm. So, but the money is not as good. So, you have to really care about what you do. You have to really care about the work. Like, if someone doesn't care about consumer protection, I'm not sure I would tell them to be a consumer protection plaintiff side lawyer. Like, just, you just want to make a lot of money. You don't care about the hours. Go to a law firm, go to a defense side. There's some people who might be really good at generating business, might be good at sort of more entrepreneurial style kind of legal theories. That might make the person a good fit for a private law firm. But again, we also really value creativity and go-getterness, not a word, at the FTC. So, lots of good options.
Is there anything, I don't know how close you've been an observer of the plaintiff's bar or, anything in the consumer space, but do you have any observations on how that space has changed in the past 10 years?
Well, you have firms like Gupta Wessler that just do extraordinary work. Really, it's wonderful to see. And I'd be curious how many of these consumer lawyers like me sort of came into this through the financial crisis. But it's wonderful to see really top-notch consumer advocacy in DC and all over the country. If you look, for example, at some of the litigation around arbitration, successful case at the Supreme Court this term, I think it was Gupta Wessler. There have been successful over the last few years. Really creative, smart lawyers. You look at what the CFPB did today, where they basically banned medical debt from credit reports. I know some of the lawyers who were involved in that process, and they come from the public interest bar, from the plaintiff side bar. I mean, these are folks who really understand litigation, really think creatively, and they add enormous value to government work.
And so then what do you see for yourself? What's top of mind for you in the coming year? I mean, of course, there's an election coming up. Very obviously, that's top of mind. That aside, or related to that, or non-obvious ways, like what is top of mind for you and the agency?
Well, I truly feel that top of mind for me is finishing the job we started over the last few years. I'm very proud of what we've accomplished across the agency, but certainly I'm partial to our consumer protection work over the last few years. I think we've gotten a lot more done than people thought was possible in the 3 years we've had so far. But there's a lot more on our to-do list. There's a lot more that we started, we need to finish. So one thing I'm committed to do is, regardless of what happens, if president's reelected, and I don't want to speculate, but one thing I'm committed to now is whoever sits in my seat a year from now, I want this good work to continue. I realize a different administration is going to come with different priorities. But one thing I really am trying to do now is to build and generate bipartisan support for the work that we're doing. We're winning a lot of that, actually. I think we're getting a lot of bipartisan support for the work we're doing. And the long-term project of making the FTC the best possible champion for the American public and for American consumers is one that I want to see through, because we have a lot of work to do.
Sam, thanks for sharing your fascinating story. I think there's lots of principles I think that lawyers of all stripes can learn from, and I really appreciate taking the time to sit down with us.
Well, it was a pleasure. Thanks for having me.
I have no idea why I said us. It's me. But,
That's fine. The team. The team.